Hi, this is Gurkaynak of Elite Attorneys at Law in Istanbul, an eminent law firm with around 80 lawyers now, 36 of whom are specializing on competition law. And I will be talking about innovation in merger control to you. So we'll be discussing the importance of innovation and dynamic efficiencies in general for competition law, and we'll also be talking about certain cases where certain worries concerning the future of innovation, if the concentration is allowed, has taken over the list of concerns of the antitrust watchdog. So to begin with, we should talk about the definition of innovation a little bit, of course. And when going into that, what better tool than freedom of speech itself to first see as a feeding factor, a true engine of innovation. So the engine of innovation is seen to us as freedom of speech for a very obvious reason, that for there to be innovation and innovative thought, there will have to be a construction on the ideas of the others. So to begin with, we need to discuss innovation itself a little bit and the environment in which innovation can flourish and function the best to maximize welfare. And in that, of course, it comes to the fundamentals of the society being being particularly accommodating for innovation. And those fundamentals are best defined through the fundamental rights and the expansion of the territory of rights, and especially in that, the freedom of speech. Because to the extent the society will have freedom of speech, that society will be able to expand the nucleus of all other prescribed rights, or at least protect them because of the freedom of speech granted to the society. And that very freedom of speech will also ensure the existence of a free market for ideas, and that market will make the better ideas more resilient, where ideas that are flawed will eventually have to perish because of the transparencies of the marketplace that is rendered so transparent also through the freedom of speech. So why is this important for innovation? Because innovation is a process, especially at this day and age, that builds on the knowledge and know-how of others. It's not a process that you lock yourself in and exclude all external ideas and just work with something that you have. It is more an interaction of ideas. It's almost like a collective brain, if you will, of the global society now, because the way a human brain works with the neurons interacting with each other, the society is now working as human beings interacting with each other's thoughts, and that is best enabled in terms of the speed of interaction and the environment of interaction and the motivation to interact best under freedom of speech environment. So once you grant yourself that quasi-philosophical but truly also legal observation, which is difficult to quantify, difficult to link truly to innovation, i.e. it is difficult to find an economical link between freedom of speech and innovation, but ultimately this particular discussion can bring prosperity to societies, the way many researchers and academicians like Amartya Sen or Daron Azemoglu are doing. So the link between democratization and economic growth, the link between freedom of speech and innovation. So what is it that we talk about when we talk about innovation? Well, innovation basically could come in the form of product innovation. It could be process innovation, incremental innovation, breakthrough innovation, sustaining innovation, or disruptive innovation. I'm not going to define each and every one of these, but to give a broader understanding of what innovation is, I will just want to concentrate on the fact that in whatever form it comes, innovation typically brings forward the competitive environment and brings forward the possibility of a given product to unleash more welfare. Now, if it's product innovation, i.e., if we're talking about innovation that really concentrates on bringing about a new product, a new functionality for an existing product, then we will be discussing about the mere and very utility that is gained out of that product. Whereas if we're talking about process innovation, we might be talking about innovations, i.e. a new way of approaching the idea of distributing an existing stream of products. So then the distribution and the journey of reaching to the end user is rendered more effective, but there is nothing new about the product itself. When we come to incremental innovation, we're talking about improvements to an existing product. So, for example, you have a VCR and there's no slow motion viewing capability yet, and someone comes up with that innovation. That is an addition to the welfare that you have, i.e. the utility you get out of viewing a certain, for example, sporting event, but ultimately there is no new product. But when someone comes up with a DVD, that is breakthrough innovation. There's a new product in town. Now, innovation, of course, does not mean the exact same thing for all of the societies around the world. For emerging markets, most innovation might be coming in the form of copycat innovation that is sustaining the innovation of others in your own society, but with your own brands or with your own follow-up action. When I say copycat, obviously I'm not referring to actual copying, i.e. counterfeit products or infringements of IP rights as a virtue. What I am talking about is bringing in technology that exists, bringing in the potential to produce technology that exists elsewhere in the world. For emerging markets, typically this might be also considered innovation. It sure is maximizing welfare. Whereas for markets that deal with the main forefront innovation, if you will, of course, you would be looking at more of breakthrough innovation, but their gain out of it and their growth out of it would be proportionally higher. All of this requires protection from the antitrust perspective. So in merger control and also in antitrust, dynamic efficiencies will be an important tool of how we maximize welfare. If economic efficiency is a target for competition law, which it is, then much like cost efficiencies and distributive efficiencies, innovative efficiencies in and of themselves would also be requiring good protection. In fact, if anything, innovative efficiencies, i.e. dynamic efficiencies, are even more precious for us because that is the true engine of maximizing welfare. When you compare your own life and the welfare amount in your own life with the welfare of your grandfather, the difference is typically owed to the dynamic efficiencies and the innovation that has gone through in the middle. The great wars that Malthus was warning us all about because of the arithmetical order production of food and the geometrical order production of human have not happened because of the innovation. So that innovation is very worthy of protecting. The only problem is we don't really know still how to protect it because it's not very quantifiable. So the very first problem of competition law enforcement is, and it truly is a problem, that whenever entities talk about innovative efficiencies, it sounds to most of the antitrust watchdogs as if they're making a story up, as if this is nice to have as paragraphs in a merger control filing, but there is no truth to it, or it's just not quantifiable, so we should disregard it. Whereas whenever it comes in the form of true anxiety, whenever the antitrust authorities see a pipeline product, for example, that may not come about if they allow two entities that are fighting for that category in their pipelines were to come together, and if that amalgamation would suddenly lose its motivation to still push forward that product in the pipeline, because it's just not going to change the competitive landscape anymore, and they should rather concentrate on their existing products' profitability, then that, of course, is a worry for competition law. That is also very good, and that should be looked into, and that is serving the interests of innovation, make no mistake. But obviously, one other virtue here would be the ability to see the proactive arguments that are presented by parties sometimes in the form of innovative efficiencies and innovation. That very rarely happens, so scaremongering through innovation does happen from time to time. Addressing true problems, it does also happen, so sometimes the enforcement is with false positives, sometimes the enforcement is spot on, but in any case, it is extremely rare to see enforcement against especially concentrations where the enforcer says, normally I would have had issues with this. From a distributive efficiency perspective, I am having question marks because would they raise the prices, for example? But they're putting such a great case of complementary R&D and complementary innovative efforts and the synergies that will come about that I will allow this. Granted, it is difficult to quantify all of that. It is easier to write than to demonstrate economically. But when this cannot be done, it is almost as if it doesn't exist, whereas we know that this exists in the real world, that we know it comes about at the end of mergers and acquisitions and joint ventures. So it's almost like we're deliberately deaf to a fact of business life when it comes to innovation analyses in merger control. So then let's talk a little bit about what's the big fuss about innovation, a little bit more about it in concrete numbers. And then let's proceed into some cases that might be helpful and interesting in seeing the struggle the competition authorities have with the integration of ideals of innovation in competitive analysis. Now, when we are looking into why innovation is such a big deal, you could also look into the market cap of companies, a comparison of last 10 years. So in 2006, when you looked at the market capitalization of the world's most valuable public companies, you would have seen ExxonMobil being at the top, and then you would have seen General Electric, Microsoft, Citigroup, BP, and Royal Dutch Shell. As you can see, there is an oil well written on this list of 2006, and then you would move on to 2016 for the market capitalization of the world's most valuable public companies, and there you would see a totally different list. Well, not totally. There's one player or two players still from the previous list, but there are so many new entrants into the list of companies with highest market capitalization. You would see Apple, Alphabet, which is Google's mother company, Microsoft, Amazon, ExxonMobil again, and Facebook. So apart from ExxonMobil and Microsoft, you wouldn't see anybody else in this list. Well, Microsoft is already a technology-driven company, so it does further our point that it is still in the list. And ExxonMobil was at the top of the list in 2006, and it is not at the top of the list anymore. It's actually 1, 2, 3, 4, 5th from the top in the list of 2016. Now, those of you who are paying close attention might say, what's the link between market capitalization and innovation and welfare? You were making a point about welfare. Well, the assumption here that I am using is that consumers wouldn't go for products that aren't serving their welfare in one way or another. And if there is such a demand to those products that the market capitalization of the company goes higher and higher because it becomes more valuable and more valuable because there's more and more place for them in the buying spree or buying behavior of the consumers, then this does naturally show us a link between the welfare of the customers and the market capitalization. So the comparison in market capitalization is very stark. From 2006 to 2016, when you compare the top 6 companies, only 2 of them remain and at lower ranks, and there are 4 new entrants, and they're all technology-driven, innovation-driven. So there is a new landscape for competition. There is a new issue to be dealt with in competition law. Of course, innovative efficiencies were always a thing. They were always important. When I had written my book that was published by the Turkish Competition Authority back in 2001, I had put forward the discussion that dynamic efficiencies should be the driving force of analysis, and competition authorities should be most careful about protecting dynamic efficiencies, that dynamic efficiency is the most mystical and therefore most fragile, but most relevant economic efficiency that is being integrated into economic growth and welfare. Now, and I'm not by any way claiming that I formed this argument in 2001. It was a kind of a new argument, especially to be made in Turkey and elsewhere as well, maybe. But there were a lot of people, a lot of academicians, a lot of judges that were discussing that we're not giving the due effort as far as the innovation is concerned, and the effect of innovation on welfare, and if the main goal is consumer welfare maximization, or as I frequently discuss, total welfare maximization, in any case, some form of welfare maximization, then innovation should be deserving more than just a lip service here and there in a reasoned decision. It should be getting full attention. It should be investigated, looked into, and protected. Now, what happens if it does not get protected? Well, of course, then very contagious effects of false positive could come about. False positive being thinking that there is a problem about innovation and not allowing a certain transaction to go forward, and only finding out later on that actually there was no such problem, but the synergies that would have come about from the transaction and the potential effect on innovation is now only a missed opportunity. And worse yet, no one will know. So it's going to be very difficult for academicians to condemn the idea. It's going to be very difficult for the people involved, for the parties involved, to revisit the idea. And it will teach something that will have a lasting effect. So others that may come up with similar ideas that actually make business sense, and that actually make business sense because it's going to change the innovative landscape, because it's going to have to change the innovative landscape, as that's the kind of ball game that's played in that market, won't happen. People will feel that this kind of transaction is not allowed, it's not supported by antitrust authorities. So going into then the idea of antitrust enforcement in merger control in connection with innovation, we need to look into what has been happening in the world so far, with, of course, selected cases, because we cannot cover all of these cases in one go, and we will visit each of the cases that I have selected, and I don't mean that these are the most relevant cases that should be selected, and that those cases that are outside of the list should not be paid any attention to, but we will make brief visits to each of them. So then, to begin with, we're looking at Medtronic Covidien, a transaction in the pharma sector. As you will find out, or you are already aware, the pharma industries are most susceptible to these innovation worries, because there is the innovative stage that is more obvious and detectable at the pharma world, which also goes into my point of earlier, which is that the competition authorities all around the world are smug in the assumption that if they cannot touch something, it does not exist. Whereas that's just not the case. It's just abnormal for competition authorities to think that so much enforcement should go on at the innovation side, at the pipeline side of things, so the product is currently not in the marketplace, but it is about to be released into the marketplace. There are clinical trials and whatnot, and so much of that enforcement is going on in pharma, but somehow, miraculously, when it's not pharma, there is no such worry or there's no such idea. I'm not trying to sell the worry, I'm just trying to show that competition authorities should keep it real, and also they should understand that there's the flip side of the coin, which is that the R&D complementation and the innovative efficiencies should also be seen as arguments that work in favor of parties wanting to do a transaction, and competition authorities should take baby steps of enforcement in those places where they cannot truly calculate the true result of their competitive actions, or their enforcement actions. So in Medtronic Covidien, what happens is that Medtronic already has a drug-coated balloon that is the market leader in treating vascular diseases. And in that drug-coated balloon market, Covidien is about to put pressure on Medtronic at a point in time when Medtronic wants to buy Covidien. And the antitrust agency looks into the matter and says, I want to protect this product called Stellarex, and I would like to make sure that when it is time to release this product, someone will actually be motivated to do this and that this will be released. I don't want there to be a storyline where I allow you to take over Covidien, and because you already have a drug-coated balloon and you're doing well in the marketplace, and because you were only feeling their potential pressure from the pipeline for that product where they would have gone forward with that innovation and they would have pushed forward with that product to put pressure on you, now you're just not going to be interested in pushing forward for that product. Why would you want two different brands in the same market? Or in any case, someone else, like Covidien before the transaction, will want it even more and will be more aggressive with that product. So I want that pipeline to belong to somebody else. Typically, the remedy has been divestiture in these kinds of circumstances, and it's notable because there must be more interesting and more complex ways of dealing with these issues. But it seems antitrust agencies felt that they're already handling something that is very mystical and fragile and difficult to handle. So they wanted to take the entire block from one place and have it be divested to another counterpart, which is what has happened in the Medtronic Covidien case as well. Ultimately, Stellarex was licensed and sold to someone else with the IP rights and with the necessary human tools and technological tools to continue with the trials and then to keep it into the market. Eventually, Spectranetics Corporation announced that it completed the acquisition of Covidien Stellarex at a later stage. So it has gone through. Another interesting case has been, again, in the pharma industry. And this time around, the parties were Novartis and GlaxoSmithKline. So in the Novartis-GlaxoSmithKline matter, the deal related to GlaxoSmithKline's oncology business. And during the transfer of the oncology business of GlaxoSmithKline to Novartis, actually the competition agencies worried that there is loss in the pipeline. In other words, there are certain innovations GlaxoSmithKline is coming about or coming up with, and those innovations are going to lead to certain products. In fact, they have phase 2 and late stage phase 3 innovations in the pipeline, and clinical trials have been successful, so it's only a matter of timing that they're going to release these products. And if Novartis takes over GlaxoSmithKline, then this is just not going to happen anymore. So there are risks for development of a certain treatment of a number of different types of cancer. The Commission expressed concerns that the proposed transaction reduces Novartis's incentives to further invest in clinical research for MEK 162 and LJX818 due to its potential to cannibalize Mekinist and Tafinlar, which are competitive pipeline products of GlaxoSmithKline, and not due to an expectation change in terms of the innovative capabilities in the MEK 162 and LJX818 as a way of approaching the innovation in these products. So, in other words, the Commission has to do something about protecting the pipeline product, and divestiture comes to rescue again. The transaction goes through with commitments in the form of divestiture and the return of MEK inhibitor to Array and the divestiture of BRAF inhibitor to Array, among other things, is committed. Array is a company. I know I'm not giving you details about companies or what is a BRAF inhibitor or MEK inhibitor, but I don't think that's the mission that I am on here right now. What I am more interested in right now is the ability to see that the competition authorities all around the world are dealing with innovation matters, and so far in the cases that I have shown, the technique has been to divest whatever is worthy of protection, i.e. whatever is in the pipeline. And the thesis I am trying to penetrate with is that it becomes visible to the competition authorities because it is in the pipeline, and when it is not visible but it is still there, but because there is no such visible pipeline as there is one in the pharma industry, sometimes they mistake and they actually enforce in transactions where they should not, or they do not take into account fully the existence of innovative efficiencies that are going to come about through the transaction. So the existence of a pipeline of clinical trials, of a long saga of tests and results should not be the only way competition authorities recognize the existence of innovation. And it is odd that innovation enforcement happens so frequently, only almost, in pharma-related markets, is what I am trying to say. And as a next example, I am giving you Pfizer Hospira of August 2015, again, looking into a similar instance of divestiture. I'm not going to go into the details, I'm just giving you the reference. Ultimately, we're talking about a biosimilar, and the biosimilar, much like a generic product does, puts competitive pressures and pricing pressures, of course, on the original product. And upon fears of certain biosimilars not becoming so relevant and therefore not worth pursuing, the Commission ultimately decides that certain biosimilars should be protected. In fact, this time around, they do an interesting thing, and they ask for a divestiture of the biosimilars by both parties to the transaction, which is going further than what has been done at the other side of the Atlantic by the antitrust authorities in the US, and they want to protect all biosimilars that are in existence through that transaction, because there will already be a certain market power in the form of original manufacturing capability after the transaction, especially. So once we've covered that basis and made one thesis that it just is unnatural and against the natural flow of life that so much innovation-related enforcement is happening at the pharma side, and it probably is because the competition authorities assume that what they cannot touch does not exist, and that this is wrong, and that much like that observation, the competition authorities all around the world should come to terms with the idea that ultimately there is a sphere of defenses available to transaction parties in the form of dynamic efficiencies to be brought about at the end of the transaction. Then I'd like to give you references to certain instances where parties came up with innovation as a defense. Of course, burden of proof being on the notifying parties to prove the existence of it, and sometimes a discussion of a balance between potential harm from the transaction with the synergies that will come about. In Hutchinson 3G UK, Telefonica Ireland, in May 2014, you have seen that kind of a discussion. In Telefonica Deutschland, E+ of July 2014, you have seen that kind of a discussion. In Hutchinson 3G UK, Telefonica UK of May 2016, that is innovation as a defense. TomTom Teleatlas, May 2008. Metso Akerkvarner, December 2006. Nokia Navtec, July 2008. Western Digital Ireland, Viviti Technologies, November 2011. In the submissions and in the discussions, there are innovative virtues and the competitive positive effects of innovation discussed in these applications. So now it is time to ask ourselves, why aren't there more of these? Isn't innovation a huge deal thing, especially in the last 10 years? How on earth is it possible for innovation to not have the exact same role in antitrust argumentation that it has in real life? If the market cap list is taken over entirely by technology and innovation-driven companies, how is it possible that the innovation discussions are only reserved to pharma companies and to some extent to certain files that I am reading are mostly belonging to 2014 and 2008 and 2011 and 2016 and whatnot? The answer is simple. The answer is that the current enforcement of the merger control analysis, the current way of approaching innovation in merger control is flawed. It is wrong to assume that only to the extent it is entirely quantifiable, these should be taken into account. Antitrust agencies might say, well, what should we do then? Should we allow people to tell us stories and walk away with transactions that might have anti-competitive effects? Of course, we're not arguing in favor of that. But now it is time to leave the notion of being smug in the comfort of assuming something non-existent because you cannot touch it and quantify it. And now is that transitory era where you have to always assume that there might be more than what you know, and therefore you go forward with baby steps enforcement instead of taking steps that cannot be undone once they're unleashed upon the transaction parties. I thank you for your time and for your patience in listening to me. I hope this was interesting.